Hey there. Thanks for clicking in. This is Amy McRoddy, your premier real estateologist, bringing you a video this week on buying a probate property in Florida. I did a previous video about selling probate property in Florida, so you might want to look at that too, so you can see what the seller's perspective is. But this one's going to be the buyer perspective. So just a reminder, I'm Amy, your real estateologist. I've been a real estate attorney and a probate attorney for 30 years in the state of Florida. I'm retired from the practice now, but you can't take this knowledge out of my head. So I'm out of the office, into the streets, out there to help you. And in this video, I'm going to let you know some quick and dirty tricks and things to be aware of when you're considering buying a probate property in Florida. And that's caveat. I don't know much about the probate law in other states. I've practiced in Florida for 30 years. So if you're thinking about buying a probate property in another state, still feel free to reach out to me. I'm happy to refer you to a probate attorney in whatever state that property's in for a real estate agent that understands the probate process. And that's the first thing you have to know when you're thinking about buying a probate property in Florida. Say that fast 10 times. You need to make sure you're surrounded by a good team that understands probate, because this can be the difference between you losing money primarily and time and ending up in some kind of a legal nightmare. Though, of course, you as the buyer, you're not going to have a lot of liability related to any purchase or sale of probate properties, but you sure could risk losing time and money if you're dealing with people that don't understand the process and people that don't have the authority to sell. That's why you need someone in your corner to make sure that the people you're dealing with are legit and have the authority. Because sometimes a lot of people just think, oh, my mom died, I'm going to sell the property, and they get with a realtor who doesn't know the difference, and they put it on the market for sale, and then they get it under contract. So say, for instance, you sign a contract and you're like, cool, I'm ready to go, I'm ready to buy this. And then the title attorney goes, no, you don't have the authority, Mr. Seller, to sell this property. First, a probate has to be open. So you have to make sure that they are doing the right thing. It's pretty easy. You just have to make sure that the person who is selling or listing the property for sale has the authority to convey to you. And the authority comes from a probate case. It's a case. It's open in probate court. It's a special division in the Circuit Civil Division where the petition for administration is filed, where the attorney says, here, judge, here's the petition. So-and-so passed away on this date, is survived by these people, and has the personal representative is this person and has these assets, period. The person who's designated the personal representative, if it's a testate estate, meaning with a will, is appointed by the court from the will. If it's an intestate case, a personal representative is also appointed. It's just that the family has to agree on who that is. And that's usually pretty easy because when the family wants to sell, they all agree and they get someone appointed. They get someone to be the point person to deal with the realtor and the lawyer and get this done. So that's what you have to make sure is done. So that's why when you have a realtor that gets the process, like me, there are others out there too. There are others, realtors and even non-attorneys that understand the process. Because again, here's the thing. When you're buying a property out of probate, you're getting involved in a legal process. It's not a normal sale. So you just have to make sure that someone's in your corner, making sure that the people that do have it listed have the authority to sell it to you before you start spending money on inspections and spending time on this deal. So that's the first thing you have to do is get a good team. You want the title company that you choose to understand probate as well, so that everybody can get nudged and move towards the same goal, which is to get the person with authority to sell, get it under contract, and get it closed and get it approved by the court as soon as possible. As soon as possible is longer than other closings. So just keep that in mind. So that's the first thing, is make sure you have a good team representing you, like your realtor, an attorney if you're comfortable as well, and a good title company like that. And then the second biggest thing is you have to know what's involved in a probate. We'll go over that. And you need to know the timing and the process in buying a probate property in Florida. So I think we went over like having a good team, right? So we know what the team is. People that understand how probate works. Even if you understand, it's good to have people on your team that also understand, because it's a collaboration and it's everybody trying to just get through the legal process that moves slow, getting through it together as quickly as possible. It's slow. It's months, not weeks. So anyway, what is a probate and why it matters to you as a buyer? Probate is a court-supervised process that validates a will or interprets the Florida intestate statute and distributes assets. That's all it is. And one of the assets is often real estate. Actually, it's usually the largest asset. It could be multiple parcels of real estate. We're just going to kind of, for simplicity in this quick video, as quick as I can make it, just kind of go about one asset, one property that you're buying. So be cautious. Don't deal with people that claim that they have the right to sell. You have to verify. Trust and verify. Otherwise, you're going to be spending time and money unnecessarily. Let's see. So who is the person that you have to deal with? The court-appointed personal representative. They have to do their job, get to the lawyer, open the probate, and get the letters of administration issued. Great. It's not a difficult process. It's what the lawyers do every day. And it's what the experienced and seasoned realtors that deal with probate assets know has to be done. So that's easy. Once you've verified that the person has the authority to sell, what's going to happen next is a little bit of normalcy. You're going to put up your deposit. It's going to be held by the escrow agent, usually the title company. You're going to be dealing with the personal representative who's going to be working with their attorney. And when it gets time to get close to closing, when title's clear and everything, then you're going to start setting the closing. Now, in order for a closing to occur, this is the little extra part, there has to be a court order approving the sale. Don't worry, sounds fancy. It's easy. It's what the lawyers and the judges do every day. But that's an extra step that takes time. So if you're looking to buy a house and move right in really quick, probate purchase may not be your jam. The other thing about probate that people think like, oh, I'm going to get it really cheap. Nope, not necessarily. You may, depending on the condition and the motivation, but you have to remember that this personal representative is a fiduciary who owes a duty to the beneficiaries of the estate. This personal representative can't just give it away or sell it to you for cheap because you're their buddy or whatever. They have a duty to the beneficiaries to get the maximum price out of that property. If they breach that fiduciary duty, they can get sued. And I know most of us are not into getting sued. It's not pleasant. It's expensive. And they probably want to do the right thing. So don't think you're going to get like this crazy deal, because they can't. Even if they wanted to give it to you for like a couple $1,000, they can't. They're exposing themselves to liability. However, most properties that are sold in probate are sold as is. Most properties in Florida are sold as is. So it's usually pretty much easier to deal with in the negotiation process with getting a reduction in price based upon conditions such as the age of the roof, the age of the HVAC system, structural, electrical, whatever. There might be some deficiencies in that property. Then you can negotiate a lower price to make allowances for those deficiencies. Also, remember, you're not only as a buyer, of course, you're pushing to get the deal and the best price, but you're going to get resistance to your lowball offers because the personal representative wants to protect themselves in that fiduciary position. And also, there may be an appraisal filed in the probate court. So when it comes to the point where petition for approval of the sale is filed, there may be an appraisal in there. And if your contract price deviates significantly off that appraised price or off a broker price opinion, then there might be some splaining to do, in the words of Ricky Ricardo. So these are just the things that you got to think about. You know, you're not necessarily going to get this crazy lowball deal because there are other factors in play that require the PR to basically get as much money as they can for the beneficiaries. And that's fair, right? And, you know, if it's not a small enough price for you, if you can't, quote, steal it, then you're going to have to move on because it ain't happening. So yeah, you get that order authorizing sale. It's pretty routine, and don't worry, you don't have to wait for the probate estate to get closed out, you know, completely in order to do the deal, because all you need is that order approving sale. The title company will take that. Everybody's bases are covered. All the other title conditions are covered, and you close. That's it. You give the money just like any other deal, and that money is not your problem. But what does happen is that the money's put in a restricted estate account, sometimes called a designated depository, and it sits there so that the people involved in the probate, the lawyers, the personal representative, the beneficiaries, they can all get all the expenses of the estate paid, and then they divide up the money. But that's on them, not your concern. You're going to pay the money just like any other closing, get the keys, and enjoy the house and give it another life. The main thing is you're going to also have to expect longer timelines. So again, if you need to move in quick, then probate may not be for you. Remember, it's going to be an as-is deal. And also know that cash is king. So, because sometimes the personal representative and the beneficiaries all agree, let's price this property aggressively because we want to sell it as quickly as possible. Maybe there are holding costs involved that they don't want to have to deal with, like paying taxes, paying HOA fees, paying for insurance, all the expenses of owning property. Maybe they don't want to carry for too long that piece of property. So they'll reduce the price to encourage a fast sale or a quick buyer, or maybe even multiple offers. So cash is king, but then be aware that you still have to go to that probate judge and get the order authorizing sale. So there might be an appraisal or a broker price opinion in that file that the judge might look at. So keep that in mind when you're negotiating. That's all. I'm back. So the main thing to be aware of when you're buying probate is it's going to take longer. You have to verify that the person you're dealing with is legit and that you're getting involved in a little bit of a legal process. It's an easy legal process generally, unless the family's fighting, but it's a little bit of a legal process. It's not a pure run-of-the-mill real estate transaction, which is why you need to have a good team in place, including me or another realtor that you trust that knows and understands the probate system, a good title company, and just people that can all work together and collaborate to get this done with as little stress as possible, because that's what's going on the other side. You're buying it, trying to get a deal and all that. The seller side are grieving and letting go of a person that they loved and a home that maybe they were raised in, that kind of thing. So just keep that in mind as well when you're buying a probate property. Now, I have a little list of questions that people have asked me about buying probate properties. So I'm going to go over them with you real quick. One is, what exactly is a probate property? So a probate property is a property that was owned by a person who is now deceased. So it's a piece of property that was owned by someone who has now transcended. Personal representative and or beneficiaries are selling that property through the process, a legal proceeding known as probate. So that's what a probate property is. Now, another question is, can I buy a house that's still in probate? The answer is yes. First of all, it needs to be in probate so that you have all the authority there. Those letters of administration are key. That gives the people authority to sell. And then once you have that, of course, you can buy a property in probate, you can close on it, and the sellers will continue to work on the other issues in their probate case. Let's see, how long does this process usually take? Okay, so I would say to budget for 6 to 9 months in Florida, just to let the probate and the title work get all cleared up for transfer of title. Do I need a special realtor or attorney? Well, of course, I'm going to say absolutely, because not only is a real estate transaction a complicated thing that people underestimate, there are so many moving parts to a real estate transaction. Now you add a probate process and Florida statutes to that, you should absolutely be represented by a realtor that knows what they're doing on a probate sale or purchase, and know that there are going to be attorneys involved, and you might even want to hire your own attorney in addition to your seasoned probate realtor. This other question, okay, do heirs automatically own the property? Well, if you didn't zip through the video earlier, I said in here that they don't. It's not automatic, not in a probate situation. So the letters of probate case has to be open, and the letters of administration have to be issued, which appoint a personal representative, and that is the person with the power to convey. Now, there are circumstances where survivors of a decedent do automatically own property, and that's if they took title. That's if the decedent put the house in a trust, and the trustee of the trust is here and alive, then that trustee has the power to convey without necessity of a probate. There's also survivorship. The people that own property, oftentimes, as joint with survivorship, oftentimes spouses. Joe and Jane as husband and wife. Joe dies, Jane automatically takes title to the property as the surviving spouse. Or John and John, or Jane and Jane. Don't forget, we have gay marriage now too, and it's tenants by the entireties. So there's an automatic transfer to the surviving spouse of the property. And in order to sell it, all they have to do is record the death certificate of the spouse that died at the closing. The title company will do that. Then there's just general joint tenants with rights of survivorship, sometimes siblings, sometimes friends. They own property, joint tenants with rights of survivorship. When one co-tenant passes away, the survivor automatically owns the property at the moment of death. There's ladybird deeds. Some people do a deed, like for instance, if I have my house, right? So in my name alone, and then I do a ladybird deed from myself to myself as to a life estate and the remainder to my daughter. Perfect. When I'm dead, my daughter gets it and she can sell it without necessity of probate. So there are ways around probate, and that's when people do smart estate planning. And they do that because they want to, they are survivors, that expense and time of probate. Because let's face it, probate costs money. Filing fees, lawyer fees, personal representative fees, creditors can come to the woodwork, all that. So if you avoid that probate process by ladybird deeds, joint tenants with rights of survivorship, and trusts, then you don't have to go through that process, and it's much easier on your survivors. And it's much easier for you as a buyer. You don't have to worry about all this stuff I just talked about. This is only for probate properties. And if you're looking at this and you're thinking maybe you might want to talk about some estate planning, reach out to me, text, email, comments. I'm happy to refer you to an estate planning attorney in Florida or nationwide. There are a lot of attorneys that are very good at estate planning. Is a probate home usually a bargain? Well, we already went through that, but just in case you skip through, they can be priced below market, but don't count on a steal. That's really it. The representative has a duty to get fair market value for the property, and that's what they're going to do. Let's see. Can I inspect the house before buying? The answer to that is generally yes. I mean, that part of it is like a normal real estate transaction. You know, you'll go, you'll see it, just like you look at any other property listed for sale. The listing agent will allow you in, you'll look at it. If you go under contract on it, you'll have your inspection period and you'll have the protections afforded you on the as is with right to inspect contract, so that if during that inspection period you find something big that you didn't anticipate as an additional expense, then you'll have the right to either cancel the contract as a buyer or request an additional repair credit from the seller. Do I need a big deposit? Well, depends on how you define big, but I would say generally look at about 10%, maybe 5%, depending upon the price. But it's got to be good faith, because again, once you get to the point of asking the judge for the approval of the sale, they're going to look at that contract and they're going to see if you've got any skin in the game or if you're just wasting their time on their end. So have it be a good faith deposit, and that is going to be determined by the price point and your realtor and your attorney, if you hire one's, opinion and strategy. And whether you have multiple offers and whether you need to be the strongest. So that's where, but other than that, it's pretty much like a normal contract as far as putting up a deposit to show them that you mean business, with a little extra in that you're going to have a judge looking at it to make sure that you're really in the game. Let's see the next question. Can the sale be stopped or contested? Well, it can be. It very rarely is, because usually the personal representative is working with the attorney and with the heirs, and they've discussed this pricing. They've, seen either an appraisal or broker price opinions. They've analyzed the pricing. So usually they're all on the same page, but sometimes there are objections to sale by heirs, and that can slow things up. And then you would just have to make a decision as to whether you want to stay in and see if everything calms down and the deal gets done, or see if you just want to get your money back, your deposit back, and move on. Most of the time, the times when objections exist are usually when one of the heirs lives in the property, because they really don't want to move. But before they list the property, one would hope that this has already been discussed and resolved so that they're ready for a third party. They've already gone through all the options and methods of how the person in the property can still be there. But you'll want to be aware, situationally aware, when you go see the property and see who might be living in there and what their attitude might be, very gently. Let's see. Is financing harder? Well, I would say that sometimes it can be. So you have to have strong proof of funds on that for sure, because the lenders aren't really, some of them, you just have to pick the right lender. That's really the deal, and have proof of funds. And if you can't, then have your proof of funds and have your pre-qualification done, and talk with your mortgage broker or lender or bank before you even submit the offer on a probate deal. That's really it. I'm not going to take up any more of your time. Once again, I appreciate your time, and you can reach out to me anytime you have any questions about buying probate property, selling probate property, right sizing, buying property, selling property in Florida. I'm here for you. Subscribe to my channel, please. Hit the little bell to get the notifications, and share the video if you think anyone might be interested in it. And that's all I got. I thank you once again, and I wish you peace and love. Bye.